Hi, this is Patrick Conroy, and we're doing Chapter 4, Premarital, Postnuptial, and Cohabitation Agreements. These are all types of contracts. Marriage itself is a contract. So these are things like contracts that can affect the marriage contract. Let's first talk about premarital agreements. Prenups. You all heard about celebrities, getting prenups so they can protect their money. It's not just celebrities. Prenuptial or premarital agreement is a contract by persons about to be married, so it's before they get married, and cover financial and related matters once the marriage occurs, and especially spousal support, property division, and related matters in the event of separation, divorce, annulment, or death. One thing you have to keep in mind of in Louisiana, we are a community property state, meaning once you get married, the default setting is community. Everything that you make or everything your spouse makes is considered community property. And community property is owned 50-50. It also means whatever debts your spouse incurs are split 50-50. Um, doesn't affect property you already have or property that you might inherit from, say, a parent. That's considered separate, even though you're in a community. But everything else is community property. You own it together. So somebody has a house before they get married, it's still their property after they get a divorce. However, the other party, if they've been hoping to pay the mortgage or the property's gone up in value, then they might have an interest in that house. If you don't want that community, you have to enter into a premarital agreement that says so, and then file that with the state. Persons likely to have premarital agreements, people who are older, because they have more stuff already. They have substantial property, they have got more stuff. Or maybe they have a business and they don't want to share the business with their spouse. A lot of times, people, once they've had a marriage and it didn't work out, they want their next one to have a prenuptial. If they already have children with others, then they might want to protect the inheritance rights of those children. The young professionals, especially if one party is shouldering the burden of putting the other one through school. You don't want that person to finish school and then divorce and say, thanks for supporting me for the past 6 years. I'm out of here. You can find all sorts of forms online for premarital agreements or prenups. What can be included? How are you going to separate the property during the marriage or upon divorce or death? Amounts of spousal support, if any, but a court can override the supporting clause, but forcing it would lead to a party becoming a public charge. So if you have a clause that says there's no spousal support, and then that person ends up having to go on welfare and food stamps, the court's going to look at that and say, no, 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 we don't want the taxpayers to have to pay for this person's life. The ex-spouse will have to pay for it for at least a certain amount of time. Or the agreement cannot adversely affect a child's right to child support and cannot control who will be awarded child custody. This is because child support and child custody aren't really the rights of the parents, they're the rights of the children. And so the parents in a prenuptial can't assign away those rights. Okay, lifestyle clauses. There have been prenups which say, if such and such gains 50 pounds, then, we will get a support and they won't get any spousal support. Those clauses are often unenforceable, but still recommended to clarify intentions and avoid possible conflict. Other clauses, like if the person gets convicted of a major crime, that can be included and will be enforceable. Or extramarital affairs, excessive, illegal drug use, those things are things, and the clauses that they trigger can be enforceable. Just like any contract, it must be entered into voluntarily. No duress, no overreaching, where one person is just, is taken advantage of. No fraud. You have to disclose any financial assets and liabilities before you go into the prenuptial. And it can't be unconscionable, meaning extremely unfair. So not to be completely fair, but not totally unfair. Fairness. Fairness can be broken up into two parts. Procedural fairness, meaning, was the process fair? Was the party provided with sufficient financial disclosure? Did they have a sufficient opportunity to consult with others? Was there duress or fraud? Was this put in front of somebody at the last minute? Were they able to practice? All states require procedural fairness for premarital agreements. Most states do not require that they meet the test of substantive fairness so long as there was procedural fairness and the agreement is not unconscionable. What is unconscionable? Those are instances where it's shockingly unfair or unjust. It's shocking the conscience by heavily favoring one side together with an absence of meaningful choice and highly unequal bargaining postures of the parties. So you don't actually have to put a gun to somebody's head for them to be under duress. It's just shockingly unfair or unjust, and there's really no opportunity for meaningful choice or negotiation. It is recommended, but not required, that both parties get independent counsel, meaning they both see an attorney that's not the same person. The absence of independent counsel may make it easier to establish procedural unfairness, unconscionability, and overreaching. So you're getting divorced, you have a prenuptial, but if you say, hey, I was not allowed to get an attorney, then you can prove that there was procedural unfairness and maybe get that prenuptial thrown out. So let's say you go to an attorney and they say, do not sign this agreement. Or the attorney fails to tell you not to sign the agreement. That means you can then possibly sue the attorney if it was an unfair agreement later on when the divorce happens. However, if you go to an attorney and they say, don't sign this agreement, and you sign it, you can't later claim that you didn't understand what you were signing. Okay, we're going to take a pause here, and I'll come back in another video to finish up. Okay, so those were all prenuptial, before the wedding. There are also postnuptial agreements. And that might be you've been married for a little while and you realize you really probably should have gotten a prenuptial, but it's not too late. This is a contract between married persons that covers specific matters, usually financial in nature. At this point, they're not intending to separate. If they do, then they should sign what's called a separation agreement. But this is just like, hey, my kid's been really bothering me about this. Can we just clarify a few things in writing? That would be a postnuptial agreement. Some reasons for entering. You had a prenuptial, but you want to update it or revoke a premarital agreement. Or to ratify the premarital agreement after a child is born, because that's been a substantial change in the relationship. And so things in the prenuptial may no longer be relevant. Or you need to clarify that they are still enforceable. Clarify what will be done with the large inheritance given to one of the spouses. And specify the terms of a reconciliation. We've broken up, but we'll get back together as long as this and this and this occur. Um, examples, more examples for reasons of entering. To set the terms of a financial transaction between the spouses, such as a plan to form a business partnership together. Who owns what? Who will do what? What will happen if the business fails? What will happen if we divorce and the business needs to keep on going? Um, how funds will be distributed from the sale of a business that one spouse began before the marriage and that both spouses ran during the marriage. Okay, these are people who are not going to get married. They are cohabiting or cohabitation agreements. This is a contract that they enter into, living together in an intimate, often sexual relationship in the manner of spouses. So they're like they're married. Now, if they formalize this, Louisiana will recognize this, meaning that there's an actual written contract um, that covers financial and related matters while living together and upon the end of cohabitation by separation and death. So if in Louisiana you have this you're living with somebody and you have this written agreement and it's been filed, then the courts will enforce it. Some states won't enforce it because they say it denigrates marriage. They say it brings back the equivalent of common law marriage that were abolished, recognizes and rewards immoral relationships. Uh, all of that, some states, Louisiana will recognize an agreement if it meets the requirements of a valid contract. Now, the consideration in that contract can't be meretricious, meaning involving sexual services. Um, that can't be part of the agreement. Now, in other states, there were cohabiting parties in this case called Marvin v. Marvin. Lee Marvin was a big actor. Lived together for decades with this other person. The other person changed their name to Marvin, but they were never legally married. So the court looked at things and said that there was an implied in fact contract, implied in law contract, quasi contract. Different states have said different things. But basically, what they've said was these people presented themselves as a married couple so that they'll be bound by some of the obligations of a married couple. Louisiana looked at this and said, no, we will not recognize a cohabiting couples unless they have a separate contract. Um, and we're not alone. Most states are reluctant to provide a remedy unless the parties have entered an express contract in writing. Okay, that sums up this. Good luck with the quiz, and let me know if you have any questions. And please comment below if you have any questions or there was something in here you were unsure about or something you found very useful. Thank you.